That is the system that we have for an annulment. More marriages, however, are likely to be terminated by the route of divorce than by annulment, and by a considerable margin. So it is useful for us to turn our attention next to the topic of divorce. Just to introduce the subject with a bit of terminology, some states will call this action not divorce, but dissolution. Nonetheless, the terminology of divorce is sufficiently widespread that I think we're probably on safe grounds using it. Just remember to use your own local vocabulary on the proper occasions. Historically, there has been an evolution in the approach of American states to the issue of divorce. Traditionally, by which I mean to say in the early 20th century and before, prior to World War II and before, divorce was only granted upon the proof of some kind of fault on the part of one of the spouses in the marriage. Starting some numbers of years ago, a few decades ago, no-fault causes of action began to be recognized by statute in a large number of jurisdictions. And at the present time, in effect, there are 3 sets of jurisdictions out there on the American legal landscape with respect to their approach to divorce. There are some small number of states that continue to adhere to the traditional policy of fault-only divorce. The largest majority of the states have hybrid systems in which they recognize simultaneously both fault-based and no-fault grounds. And then finally, we have a small number of states that have abolished the fault grounds and are no-fault only, like California. Under that pattern, it is probably necessary for success in almost any domestic relations course to understand both the fault grounds and the prevailing system of no fault. The fault grounds are usually quite easy to appreciate and understand. Pardon me. There are some differences from state to state, but we can fairly well generalize 6 fault-based grounds that are nearly universal in the United States. First ground is the ground of cruelty. Cruelty. Some states will separately itemize physical cruelty and mental cruelty. I am lumping them together for ease of discussion. Cruelty. States have a wide variety of different names that they can use to label this behavior. Some states refer to physical cruelty as cruel and inhuman treatment. Some states use the phrasing cruel and barbarous treatment. Mental cruelty is sometimes referred to as indignities. But whatever the name, the approach to these grounds is usually quite similar. Physical cruelty means physical conduct that endangers the health or well-being of the victim's spouse. The legal question that comes up in physical cruelty cases that has been somewhat troublesome is the question of whether or not a single episode of physical cruelty is enough to make out the grounds, or whether it requires a repeated pattern of abuse. Most jurisdictions have adopted the following response to that question. If a single episode is life-threatening or poses the danger of severe physical injury, then the single physical episode will by itself be grounds for divorce. Otherwise, we must look for a pattern. The fact that, after 6 years of marriage, a husband loses his temper and slaps his wife with an open hand in the face is probably in most jurisdictions not enough to make out physical cruelty. But if, after 6 years of marriage and no violence, the husband loses his temper and breaks a chair over the head of his spouse, that surely would be considered sufficient physical cruelty to grant a divorce in most states. Mental cruelty is more subjective and almost always requires a continuing pattern of conduct. Mental cruelty can take the form of denial of sexual access, refusal to socialize or interact with the spouse, hostility, verbal abusiveness, and may even include problems that arise from habitual drunkenness or drug addiction. So that's the cruelty ground for divorce. Second ground for divorce, I think virtually universally recognized in states that still have fault grounds on the books, adultery. Adultery is voluntary sexual intercourse with someone other than your spouse. Voluntary sexual intercourse. Not that any right-thinking person would assume it to be true, but for the record and to be official about it, if a spouse is raped, that rape does not constitute adultery and therefore does not give grounds for a divorce. Although we word the definition of adultery in terms of sexual intercourse with someone other than your spouse, there is authority suggesting that homosexual activity will also be treated as the equivalent of adultery and be grounds for divorce. It raises a minor semantic problem because acts of gay or lesbian sexual intimacy do not take the form, technically speaking, of intercourse. They take the form, technically speaking, of sodomy, but courts have recognized that as adulterous. On the other hand, you should note that in most jurisdictions, because of the way these rules are worded, the activity must be with another person. Conduct with other members of the animal kingdom, or for that matter, inanimate objects, does not constitute adultery. Third grounds for a divorce, desertion. Desertion. This is again exactly what it sounds like. There is no great mystery or sophistication here. This is walking out on your spouse. Usually, to be more formal about it, desertion is defined as a voluntary separation with an intent not to return, without consent of the spouse, and without justification. In effect, 4 requirements. Voluntary separation, no intent to return, no consent of the spouse, and no justification. By justification, incidentally, note that, for instance, if you are being battered, if the wife, as is so typically the case in these fact patterns, is the victim of physical abuse by the husband, and she leaves that household with no intent to return and without consent of her spouse, she is not a deserter because she has a justification. In almost all states, the desertion must be for some specified minimum period before it gives you grounds for a divorce. The most common period that I'm familiar with is a year, but obviously the jurisdictions can differ. The only other thing about desertion that you should be aware of is that desertion can be constructive as well as actual. Constructive desertion can be, for instance, refusing to accompany a spouse when the spouse has to relocate for a certain reason. For instance, let us say that one spouse is in the military service of the United States and is reassigned from a position in Kentucky to a position in Southern California. Let us say that the spouse of that service member refuses to accompany the service member to the new location in Southern California. The refusing spouse is a deserter, even though that refusing spouse may never physically leave the house. The refusing spouse may be sitting there in the den in Kentucky, never moving, but they are a constructive deserter because of their failure to follow the military service member to the new location. You can also be considered a constructive deserter if you basically shut off all communication and interaction with your spouse. If basically, although living under the same roof, you become a stone wall and you give your spouse the silent treatment. That becomes effectively constructive desertion. Grounds number 4 for a divorce, non-support. Failure to provide economic support, as is the duty of a spouse to another. Ground number 5. Criminal conviction and or incarceration. Criminal conviction and or incarceration. After the couple has gotten married, one spouse is convicted of a crime. Some states will only make this a grounds for divorce if, as a result of conviction, the spouse is sent to jail and sent to jail for some specified period of time. The notion being that if you're sent to jail for 2 months or 3 months, your spouse should be patient. If you're sent to jail for 10 years, there's not much of a marriage, and therefore we should give grounds for a divorce. Finally, number 6, insanity. If after the marriage, if the parties were lucid and had mental capacity at the time the marriage was entered into, but if after the marriage one party loses his or her mind, then the other party may attempt to extricate themselves from the marriage, in effect the argument being that the person with whom you entered into the marriage no longer exists. That person has gone away and has been replaced by this person who suffers from the mental disease. So those are the 6 principal fault-based grounds that we find around the country today. Let us take a look at the no-fault system of divorce and the principal ground that prevails for no fault. The ground for a no-fault divorce is usually characterized as irretrievable breakdown of the marriage. Irretrievable breakdown of the marriage. There are, of course, other names that capture the exact same concept around the country. Among the other names that we see are irreconcilable differences and incompatibility. Incompatibility. Whatever the name, the notion is the same. That for no single identifiable reason, the relationship that once existed has deteriorated, the parties have grown apart, and they do not wish or do not believe that they can remain together as a husband and a wife. Most states distinguish between those circumstances where both parties agree that the marriage is irretrievably broken and those situations where only one party thinks that that is the case. Where both parties think that the marriage is irretrievably broken, you have in effect a mutual consent no-fault situation. And in a mutual consent no-fault situation, usually the divorce is available on a fairly accelerated schedule. On the other hand, if only one party alleges irretrievable breakdown and the other party is resisting that conclusion, courts usually, state statutes usually require a substantial waiting period before the divorce will be granted. In effect, the party seeking the divorce files a complaint and then moves out of the household. And then there is a statutory period of separation. Perhaps 6 months, perhaps a year. Some states it may even be as long as 2 years. Only after the period of separation has elapsed will the parties be then granted their no-fault divorce. Some states have gone to the extreme of granting streamlined or accelerated divorce in a procedure that is usually referred to as summary divorce. This is available only when the couple has minimal financial assets and has no kids and has been married for a relatively short duration. The summary divorce procedure basically allows the parties to get divorced on the papers without the appearance of counsel and without the need to hire attorneys. It is streamlined, but as I say, only available for certain couples who meet those requirements of having uncomplicated relationships. There's a bit more for us to say about divorce, but it seems to be a good juncture for us to take another short break, so why don't we do that and resume in just a moment. These might be raised as affirmative defenses to a divorce complaint. And so it's important for us to take a quick look at these, although many of these defenses have fallen into disfavor, and indeed some have been substantially abolished in most American jurisdictions. The first thing to note about divorce defenses is that they are only relevant in fault-based cases. By definition, in a no-fault divorce, there is no occasion to assert a defense because no one is being accused of any wrongdoing. But in a fault-based case, there are at least 4 classic divorce defenses that we should just spend a moment on. The first of them is a defense usually called recrimination. Recrimination, I think, is best analogized to the concept of dirty hands under equitable principles. In other words, the notion is that you show, as the defendant in a divorce action, that the plaintiff's spouse is guilty of comparable misconduct. The classic example was in an adultery case. In an adultery case, let us say that the husband sues the wife for adultery, alleging that she is sleeping with a colleague at the law firm where she is employed. The wife turns around and sues the husband, or defends the claim, I should say, by alleging that the husband is guilty himself of adultery in that he is sleeping with a coworker at his place of employment. That would be the defense of recrimination. And under the traditional approach, that would be a good and valid defense that would prevent the issuance of a divorce. That defense is one of the ones that has been abolished in a vast majority of jurisdictions. It really is now quite obsolete, and when you think about it, that makes perfect good sense, because the recrimination defense really, in some sense, relied on a rather bizarre logic. You have a situation where one litigant comes to court and says, our marriage has been destroyed because my spouse is cheating. And the judge, presumably at that moment, is thinking, you're right, we should dissolve this marriage. But then the defendant's spouse leaps up and says, well, wait a second, I'm not the only one who's cheating. Plaintiff's spouse is cheating too. And at that moment the judge says, well, my goodness, that's a completely different story. You two were made for each other. Go home and live together as husband and wife. Doesn't exactly make a great deal of sense, and so for that reason most jurisdictions have abandoned recrimination. Another defense that was traditionally available, and this one I think continues to retain some force, is a defense called condonation. Condonation as in the word condone. This is effectively a form of waiver. Typically it means that after becoming aware of the divorce ground, you continue to cohabit with your spouse and in effect engage in conduct that amounts to a waiver or a forgiveness. Classic example, again, is adultery. Let us say that the husband is engaged in adulterous conduct. Let us say that he breaks off the adulterous affair. Let us say the wife is aware of it. Let us say that after a period of marital tension, they resume marital cohabitation. And let us say that that is a cohabitation that includes within it not just physical intimacy, but a forgiveness, a looking beyond the adulterous episode. At that point, the innocent spouse has waived the ground of adultery. She cannot thereafter attempt to resurrect that ground and file a divorce complaint, because if she does do that, the husband will probably be able to assert the defense of condonation. The third defense, perhaps the strangest of the four, it's called connivance. Connivance. And I've always thought of connivance as on a rough analogy to entrapment. In effect, it means that the grounds in question, the alleged misconduct committed by the defendant's spouse, were procured by the plaintiff's spouse. That the plaintiff's spouse literally arranged or connived to get that defendant's spouse to do the bad deed. Again, adultery forms a very good illustrative fact pattern. We might have a situation where a wife, eager to obtain grounds for a fault-based divorce against her husband, hires someone to seduce the husband. She pays someone to approach him, make sexual overtures, and see to it that he ultimately gives in to those overtures and commits an act of adulterous intercourse. Under those circumstances, when the truth comes out, the defendant's spouse can raise the issue of connivance as a defense. Finally, we have the defense of collusion. Collusion is equivalent to fraud. Collusion means that the parties have trumped up the grounds for divorce. They've fabricated the grounds. Collusion used to be a major problem in domestic relations litigation, in divorce litigation, because prior to the advent of no fault, couples who had become estranged from each other had no recourse except to lie about the grounds. It was, in many circles, considered quite chivalrous for a man in a failed marriage to confess to a fictional adultery. The wife would accuse him of the fictional adultery, and they would proceed thereupon to perpetrate a fraud on the court. If that were to become apparent, or if one of them were to change his or her mind midway through the litigation, that could be raised in defense of the action. In many respects, while this is still on the books as a legal doctrine, it's obsolete. It's obsolete because if both parties are willing to collude in order to obtain a divorce, there's no longer in most jurisdictions any necessity that they do that they can simply secure a mutual consent, no-fault divorce on the ground of irretrievable breakdown. Why would you subject yourself to the possible penalties of perjury that are inherent in the collusion fact pattern when you can so easily obtain a divorce through another mechanism? So, while as a practical matter not terribly important, in the few jurisdictions that do not have no-fault grounds, it could conceivably come up. Now, we've covered two of the three matrimonial causes of action available for the dissolution of a marriage relationship. We've talked about annulment and we've talked about divorce. It remains for us to take a brief look at the action for legal separation. The action for legal separation, like the other two, is subject to variable terminology around the country. This is sometimes called divorce from bed and board. Divorce from bed and board. That's a somewhat dated terminology, but you do occasionally see it around the country. Some jurisdictions even refer to this as limited divorce. I think it enhances clarity for you to stick with the phrasing legal separation unless you have a clear indication from an instructor that that instructor would like you to use the other terminology. Legal separation is a mechanism that does not dissolve a marriage. You can think of it as a mechanism that puts the marriage on hold, that puts the marriage into a deep freeze or a suspended animation. And by suspending the marital obligations, it substitutes court-ordered obligations such as duties to pay support pursuant to a particular court order. But the key thing to remember in a legal separation action is that at the end of the day, the parties remain legally married. Now, why would parties who are having difficulty pursue legal separation in lieu of a conventional divorce? The answer is that first, there may be hope of reconciliation. They may feel that at the moment things have gotten quite ugly. They may feel they need the assistance of the court in sorting out issues such as who gets to keep the marital home or how much money should be paid in support from one to the other. But they may hold out hope for eventual reconciliation. Second, they may feel that it is necessary to preserve the formal marital bond for a variety of pragmatic reasons, financial reasons, tax reasons, to ensure entitlement to a variety of government benefits. And so legal separation may be attractive for that reason. Finally, some couples may find it necessary to pursue legal separation for religious reasons. They may belong to denominations or faiths that forbid divorce, or at least forbid divorce except under certain circumstances. They may feel that they are in an unworkable relationship and that legal separation affords a good compromise between the pragmatic needs and their religious belief system. Now, in order to get a legal separation, usually in most jurisdictions you have to assert grounds. And the grounds typically track the grounds that we canvassed when we discussed divorce. You could obtain a legal separation, for instance, if your spouse is an adulterer, or you could obtain a legal separation if you are the victim of cruelty. Quite often, however, the ground for legal separation will be non-support. Quite often, that becomes a very prominent issue in legal separation proceedings, and it becomes, therefore, quite bound up in a court order mandating the payment of support at the end of the legal separation procedure. So those are our three matrimonial causes of action. In all three, it is necessary to consider a variety of procedural issues. And I think that it's probably fair to say that in most courses on family law, those procedural issues are usually framed in terms of divorce procedure in particular. So let us shift our attention and take a couple of few minutes to take those procedural issues up in turn. The first question, of course, is a question of subject matter jurisdiction. What court do you go to obtain a divorce, or for that matter, separation or annulment? I suppose my somewhat flip answer would be, well, I couldn't begin to tell you it's different in every state. But I can tell you at least one thing. And what I can tell you is this. You cannot go to federal court. Not even if there is diversity of citizenship. There is a well-recognized exception to federal diversity jurisdiction that basically forecloses any access to federal court for matrimonial claims. So you have to go to state court. Which state court will be a matter of state law. There are two basic patterns with a lot of subsidiary variations. In many states, you go to the basic trial court of general jurisdiction, whatever it may be labeled, the state district court or the state superior court or the state supreme court. In New York, the lowest court in the system being called the Supreme Court. In other states, you may go to particular courts that are constituted specially for the purpose of hearing matrimonial causes of action. It may be called the family court, it may be called the domestic relations court. Now, once we have subject matter jurisdiction, there's a second procedural issue or second prerequisite to obtaining court intervention that must be observed, and this is rather unique to domestic relations litigation. Virtually all states require that at least one litigant meet a residency requirement, a durational residency requirement, before the court will act on their application for matrimonial relief. In effect, usually that is applied to the plaintiff's spouse, although the residency requirement can be satisfied by the residency of either. And in effect, this is sort of an unusual situation because in most types of litigation, the mere act of presenting yourself on the courthouse steps with a complaint makes you as the plaintiff entitled to go forward, assuming you can get jurisdiction over the defendant. But in matrimonial causes of action, the plaintiff, in effect, has to show connection with the forum by virtue of this residency requirement. How long is this resident requirement going to be? Well, obviously it's going to vary from state to state. The Uniform Marriage and Divorce Act, which has been adopted in a number of states, specifies 90 days. But there are longer periods out there around the country. Some states require 6 months. Some states require a year. There are a handful of states that have shorter residency requirements. I suppose Nevada is the most famous of those, which is why it was traditionally the forum of choice for persons seeking rapid divorce relief. The issue of these residency requirements was about 20 years ago called into question on constitutional grounds, but the United States Supreme Court, in a case called Sosna, upheld these durational residency requirements as a legitimate exercise of state power, so there is, in the contemporary climate, no doubt that the states can impose and enforce these rules on plaintiffs. Now, assuming that I'm in the right court, and assuming that I, as the plaintiff's spouse, have satisfied the durational residency requirement, the next thing I need to do is obtain personal jurisdiction over the defendant. Now, having said that, I'm going to immediately contradict myself. I need to obtain personal jurisdiction over the defendant, but if I, as the plaintiff, am domiciled in the forum state, then the court does have jurisdiction to grant a divorce or an annulment regardless of personal jurisdiction over the defendant's spouse, if I am domiciled in the state. The reason for that is because marriage is considered to be a thing, a race, R-E-S, a race, like a piece of property. And the court will be deemed to have in rem jurisdiction, provided I am domiciled in the forum state as the plaintiff. And if the court proceeds on this in rem theory, with no personal jurisdiction over the other spouse, but with the plaintiff being domiciled in the forum, then that divorce decree is valid and binding, and the other states of the United States must give it full faith and credit. Note that that operates even if the divorce is granted ex parte. The Supreme Court determined that particular issue 50 years ago in a case called Williams versus North Carolina, and it is well accepted. Plaintiff is domiciled, in rem jurisdiction obtains. But note that under that circumstance, with no personal jurisdiction over the absentee spouse, the court cannot enter any orders concerning economic issues. No orders concerning alimony or property division would be valid. That would violate due process because there's no personal jurisdiction over the absentee. Now, having said that much, I guess I should pause briefly to elaborate on the concept of domicile. I suspect you've encountered this in other branches of your studies, but domicile is, of course, more than mere residence. Domicile means not only that you reside in a place, but that it is the place that you call home, it is the place that you have no intention to leave, that for the foreseeable future you plan to remain there, or whatever definition may be used in your home state. So the domicile concept is one that you should be conversant with to make sure you understand this in rem jurisdiction to grant a divorce. Now, let's assume that you want more than just a divorce. Let us assume that as the plaintiff in a matrimonial action, you want economic relief as well. Now, not only must you satisfy the subject matter jurisdiction requirement of picking the right court, and not only must you satisfy the durational residency requirement imposed by your state, you must secure personal jurisdiction over the absentee spouse. How do you do that? Well, you can do it if the other spouse is a domicile of the forum. If the person is a domicile of the forum, then the forum has personal jurisdiction, and you can serve them pursuant to the service of process rules, and you will be fine. You can also do it if you are able to serve them with a summons while they are physically present in the jurisdiction, even if it's not their domicile. Maybe they've come to visit. Maybe they've gone to see a play or an opera. Maybe they're changing planes at the local airport. If you can slap them with a summons while they're in the jurisdiction, you've got personal jurisdiction. Third, perhaps they will consent to personal jurisdiction. Perhaps the forum is a convenient and sensible choice of forum, and perhaps the defendant spouse is just as eager as the plaintiff to get a full adjudication of the economic issues. And finally, you are, of course, free to attempt to rely on a long-arm statute, to attempt to show that there are minimal contacts between the defendant and the forum state. For instance, maybe the grounds occurred in the forum state, the grounds that give rise to the particular claim or cause of action. For instance, maybe the plaintiff has filed a divorce claim in the state of Massachusetts, and maybe the allegation is that the defendant committed adultery in a Boston hotel. That would be sufficient minimal contact with Massachusetts to grant long-arm jurisdiction. Or it might be because the state is the state where the couple had originally been married. Or it might be that they formerly resided in the state as a married couple. All of these things would probably constitute minimum contacts, so that even though the defendant's spouse has moved away, the defendant's spouse can be properly served and made to answer in that particular forum. These kinds of issues come up quite frequently because it is often the case that instructors will give you problems where an actor has left a particular state and gone elsewhere to secure a divorce. This is a form of matrimonial forum shopping. It is sometimes called migratory divorce. When you analyze these problems, be sure to work through the full analysis that we just looked at. Make sure that the forum shopping spouse, the plaintiff spouse, the migratory spouse, has established domicile in the forum state. Because if there's no domicile in the forum state, then there's no in rem jurisdiction over the marriage, and therefore no requirement that other states grant full faith and credit to that divorce. The only exception to that is if, notwithstanding the absence of domicile on the part of the plaintiff, the defendant voluntarily appears. If the defendant voluntarily appears, then we have a bilateral divorce, and in that case, the bilateral divorce will get full faith and credit substantially on the logic of collateral estoppel. Substantially on the logic of collateral estoppel. For instance, let us say I have a couple, and the couple has resided and currently still does reside in the state of Virginia. And let us say that they have entered into a state where there is some marital difficulty. Let us say that one partner in that couple is in Florida. Perhaps he's vacationing there. Perhaps he has business there. He's vacationing in Florida. He files a divorce complaint in Florida. He is not a resident of Florida, and he is certainly not a domiciliary of Florida. He serves that complaint on the wife in Virginia, the home state. The wife decides that Florida is as good a forum as any, and that she could use some sun and a visit to the beach, so she flies to Florida, enters an appearance, and Florida adjudicates the issues in the divorce. Presumably, Florida would demand the observance of some resident requirement on the part of either spouse, but let's assume that that was satisfied. Thereafter, if the defendant wife were to challenge the proceedings in the Florida court on the grounds of lack of jurisdiction, she would fail, because having voluntarily appeared, she is collaterally estopped from protesting the jurisdiction of that court. Consequently, other states will give full faith and credit to the bilateral divorce that occurs at a state. That was decided, incidentally, by a Supreme Court case called Shearer. So Shearer and Williams together constitute the Supreme Court authority on full faith and credit for out-of-state divorce. Full faith and credit if plaintiff was domiciled in the forum, or full faith and credit if it's bilateral. And remember, in either scenario, no monetary orders are going to be entered unless there is personal jurisdiction over the defendant spouse. Let me say a word, since we've been talking about conflict of law issues, about divorces granted outside the United States, foreign country divorce. Foreign country divorce is quite different than out-of-state divorce because there is no constitutional imperative that would force one state to recognize the foreign country divorce. There's no legal obligation. Therefore, each state is free to give recognitions to foreign divorces based on its own perception of public policy. The general rule is that certain foreign divorces will be honored under the doctrine of comity, C-O-M-I-T-Y, but only if certain requirements are met. Basically, states look for a bilateral foreign divorce where at least one party has actually traveled to the forum nation. Bilateral and one party actually appears in the forum nation. They will also look to see whether or not the underlying procedure has some legitimacy or seriousness associated with it. Was there hearing? Was there evidence taken? Was there sworn testimony and the like? By and large, a mail order foreign divorce is not going to be recognized by any American jurisdiction. Mail order in this sense meaning that neither party travels for an in-person appearance before the foreign national court. Similarly, an ex parte foreign divorce is not going to be recognized. A foreign divorce where, although the plaintiff has traveled to the foreign nation, no notice was provided, no service was made, and no participation was had by the absentee spouse who stayed back in the United States. So look for a bilateral divorce and look for participation by one spouse on the scene in the foreign country. All of that takes us to the fourth principal topic of this presentation, which is the topic of economic issues confronted upon dissolution. Economic issues can be addressed in either of two ways. The parties can attempt to address them by their own mutual negotiated agreements, or in default of an agreement, the court can take it upon itself to resolve them for the parties. Let's talk about agreements first. And indeed, there isn't that much to say about agreements except to note their possible applicability in this situation. The typical agreement that we would confront dealing with economic issues upon dissolution would be a separation agreement. That's the typical term or typical designation for an agreement of this type. This is an agreement in contemplation of divorce. For those of you who may have been aficionados of LA law, this was the document that Arnie Becker was presumably always concerning himself with drafting before the participants would have a riot and tear up the conference room. To be a valid separation agreement, the agreement must be freely made and it must be in writing. It must be freely made and it must be in writing. The subject matter of the agreement can range over any issues the parties wish to address. It can include specification of how property will be divided, with lengthy schedules indicating not only who gets the large assets, such as the house and the car, but detailed itemization of who gets each and every piece of art and who gets each and every piece of china and silverware. It can cover the question of support or alimony. What will be the size and magnitude of payments? How long will they last? Will there be any escalators up or reductions down? It can cover testamentary issues, waiver of a spouse's elective share, or contracts or promises to make certain provisions in a will. And indeed, the agreement can even cover issues relating to children. Who's going to get custody, what will be the visitation arrangements, how much child support will be paid, and so on. By and large, courts will enforce a valid separation agreement as written and leave the parties to live with the bargain they have negotiated. The only exception are provisions relating to children. The court will always reserve the prerogative to amend those provisions to ensure that the child is well provided for and that child's best interests are being served. But beyond the provisions of the instrument that relate to children, the court will give effect to the bargain of the parties. In order for the separation agreement to be valid, you should basically run the same analysis in your head as you would use for a prenuptial agreement. You should look for full financial disclosure. You should look for fair and equitable provision for the less well-off spouse. There can be problems with the separation agreement if it is unconscionable, if it does not make a fair and equitable provision, or if assets were concealed and no full disclosure was made. For both prenuptial agreements and separation agreements, it is always preferable that each party have separate counsel. It is a red flag concerning the validity of these agreements if a single lawyer prepared the agreement and purported to represent the best interests of both spouses at the same time. So that's the kind of agreement that we may have, and if we have it, our life is made much easier because the parties themselves have come to an accommodation as to how to split the assets. Assuming we don't have an agreement, we are then remitted to the court's best judgment as to what to do. And in this regard, I want to take you through a number of different subtopics. The first thing to note is that because matrimonial litigation may last for an extended period of time, indeed because there may be statutorily imposed waiting periods, parties may find it necessary to obtain interlocutory or temporary relief during the pendency of the action. Once the divorce complaint has been filed, there is probably considerable tension in the relationship, and it may be that the parties need the assistance of the court. The court has considerable power to enter such orders while the litigation is pending. Those orders can relate to the payment of support during the pendency of the action. While this case is pending, husband shall pay wife $2,000 a month. That support obligation is usually referred to as alimony pendente lite. Pendente, new word, Lite. It's Latin. It means while the litigation or while the lawsuit is pending. The court can also enter temporary orders relating to possession of particular assets. That's particularly important in terms of indicating who gets the house and who gets the cars. The court can also enter temporary orders unrelated to economics, but rather related to the personal safety of the individuals involved. Many states have adopted special statutes granting the courts enhanced powers in this regard. These can be protective orders, requiring one party to vacate the home and stay away from the other spouse. These can be issued in many instances on an expedited basis and indeed even on an ex parte basis without notice to the other spouse if the court is convinced that there is an actual and imminent danger to members of the family. So whenever you address a problem on an examination and you're looking at an issue of relief to be granted by a matrimonial court, you might want to observe in passing that even before the case is resolved, the court has the power and indeed may have a very valid reason to enter these temporary orders. Now let us assume that we've moved to the conclusion of the litigation. What are the principal economic issues that the court will then address at the conclusion of the issue? Well, at the conclusion of the case, the court will address first the question of alimony. Alimony, like every other domestic relations term we've stumbled across, has a number of synonyms that are utilized in different states around the country. It is sometimes called support or spousal support. It's sometimes called maintenance. In most jurisdictions, before a court will even address the question of the appropriate amount of alimony to be paid, or even whether any should be paid, the court will require the parties to file financial disclosure forms. That, in effect, puts the court in the same position as the parties themselves would have been in had they been able to negotiate a separation agreement. Alimony in the contemporary landscape of American family law is only ordered when necessary. Alimony is not an entitlement. Alimony is only ordered when necessary. The approach of the Uniform Marriage and Divorce Act is somewhat illuminating on this. The Uniform Marriage and Divorce Act says that you are entitled for alimony only if you lack sufficient property to care or take care of or provide for your reasonable needs, and you are unable to support yourself through appropriate employment or because you are the custodian of minor children, and that makes it impossible for you to work. Note that the first part of that test, the reference to lack of sufficient property to support or provide for yourself, suggests that there is an inherent connection between property division and alimony. If a spouse is awarded large amounts of property as part of property division, that may eliminate the need for alimony, particularly if the property is income-producing property, an apartment building that throws off a rental income, shares in a mutual fund that throw off dividends. So be sure to take into account property division and the consequences of property division in determining whether or not you are needy for the purposes of receipt of alimony. It was traditionally the case in older American jurisprudence that there was a presumption of alimony flowing from the husband to the wife, but it should come as no surprise to anyone that in the contemporary climate, gender-based rules concerning alimony are no longer observed. Indeed, the Supreme Court told us in 1979 that those rules would be unconstitutional. Alimony is issued, therefore, or awarded, therefore, solely on the basis of need. The Supreme Court case is Orr versus Orr. How much alimony does the needy spouse get? What is the quantity of alimony that will be awarded? Well, the answer is that it will be awarded within the discretion of the court. The court will decide. How does the court do that? It relies on an itemized list of factors in most jurisdictions, and that list varies in its particulars, but the main contours are usually pretty similar from place to place. Let me give you some of the principal factors bearing on the amount of alimony that come from the Uniform Marriage and Divorce Act. It refers to at least the following factors: the financial resources and property possessed by the recipient, the time necessary for the recipient to secure education and training, the standard of living during the marriage, the duration of the marriage, the age, physical, and emotional condition of the recipient, and the resources of the payor. All of these things will be balanced and taken into account. The most controversial factor of all in the issue of fixing alimony awards is the issue of marital fault. The uniform statute says that marital fault is not to be considered, trying to eliminate any reference to alimony as punishment or any reference to alimony as dependent on good behavior. But many jurisdictions, notwithstanding the Uniform Act, continue to treat marital fault as a relevant variable in fixing the amount of alimony. This is particularly the case when the needier spouse, the poorer spouse, is also the faulty spouse. Let us say I have a situation where I have a couple. The wife is an attorney. She works as an associate in a large urban law firm and earns a very significant wage as a senior associate. The husband is a freelance artist. Let us say that as a freelance artist, his income is sporadic and often not very substantial. Let us say that during the course of the marriage, he becomes physically abusive and begins engaging in acts of physical cruelty directed at the wife. The wife sues for a divorce on grounds of physical cruelty. The husband, during that proceeding, asserts a claim to alimony. He is plainly the needier of the spouses. He is probably not going to be able to support himself on the facts that I've described. Many jurisdictions would nonetheless reduce or perhaps even deny him alimony if they find